Hello, everyone, and welcome to tonight's session, Getting Exceptions Right, a View from the UK. This is our first webinar of our first virtual forum. I'd like to begin by paying my respects to the Ngunnawal people, the traditional owners of the land here in Canberra, where I am. On behalf of the ADA, I'd like to acknowledge their elders past, present, and emerging. A few housekeeping notes before we get started. Please feel free along the way to ask any questions using the chat function. Any comments that you'd like to add, please use that. You should also feel free to use the raise hand icon as well. And I will prompt you along the way to unmute your microphone, and you should feel free to ask questions that way as well. Now with that, I'd like to introduce our two speakers tonight. We are joined by Dr. Emily Hudson, Reader in Law at King's College London, and Emeritus Professor Jill McKeough, who are both joining us on screen now. Hello, Jill. So with that, and we've got Emily there as well. Hello, Emily. So with that, I will hand over to Emily, who is going to kick things off this evening with a short presentation, and then we will jump straight into it. So thanks, everyone. Emily, I will hand over to you.
So hopefully you have my slides and that my audio is now working. So thank you to Ben and the ADA for the introduction. Thank you to Jill for also agreeing to take part in this seminar. That's very exciting. I'm going to pick up where the recorded video left off by drawing from my book and indeed other research to make some comments about the proposed copyright access reforms. I should add that if you haven't watched the video, that's okay. The presentation is entirely self-contained and you can watch the video later or not at all up to you. I'm going to use the fair use panacea as a launch pad. So the fair use panacea is the idea that countries with a closed list approach to exceptions. So that is purpose-specific fair dealing exceptions and detailed specific provisions should enact an open-ended fair use exception. Paring things back to the basics, the logic goes that closed exceptions face problems due to their drafting style in terms of over and under inclusiveness and failure to keep pace with technological developments and other creative practices, that these problems are inevitable given the drafting style, meaning that we end up in endless rounds of law reform, and that the best way to deal with all these problems is by enacting a fully open-ended exception in the style of fair use. As I said, that's very much the summary version. I don't want to discount entire books or ALRC reports that have developed these arguments in full. So, turning to the Australian reforms, and the first thing to note is that the Australian government has decided not to introduce fair use, raising the question of whether the ADA and other copyright stakeholders should redouble their efforts to lobby for fair use. Now, I've been thinking about this question in relation to the United Kingdom because of Brexit. So Brexit means that the UK government now has far greater freedom in relation to copyright, and indeed the question of fair use might be put back on the table. But my answer for fair use, my answer for the UK, I should say, is that fair use is the wrong question, at least for now. and at least in isolation. And in saying this, please bear in mind that I am on the record as supporting fair use in Australia, and my book really makes the case in favour of fair use. I want to speak to some of the reasons for my suggestion that in the UK, fair use is the wrong question at the moment, because they might chime with an Australian audience. So one reason is legislative bandwidth, that implementing fair use is not a small project, and the evidence at the moment suggests that this is not a priority for the UK government. There's also political attractiveness, that even if such bandwidth emerges, we need to be cognizant that if other countries such as Australia are anything to go by, and I think they are, we would have a review process which is polarized and in which respondents argue emphatically both for and against fair use. And in the face of this resistance and apparent conflict, the government may be reluctant to adopt fair use if other intermediate positions are available. Turning then to the other two bullet points, even if we have the legislative bandwidth and the political will, the case for fair use assumes that a change to the law and books will translate to a change in the law in action. But there are numerous examples of where this has not occurred, including the Australian experience with Section 200AB. So Section 200AB was introduced in 2006 with the aim of capturing, for some uses and users, some of the benefits of fair use. But empirical evidence suggests that, at least for cultural institutions, it's on the margins of practices, and that it is used rarely and as a sort of de facto orphaned works provision. The flip side of this as well is that you don't necessarily require a change to the law and books in order for there to be new norms and practices that emerge. Indeed, in Australia, it even seems to be the case that legislative inertia has encouraged a norm of risk management. That is, we've got no fair use, no exception dealing specifically with orphaned works, Section 200AB being perceived as incomprehensible. And in the light of all the sort of delays in the Australian government doing anything to rectify the situation in relation to exceptions, institutions have had to upload their own solutions. And for orphaned materials and unpublished collections, there's often a sort of ideas of risk management that inform decision-making. Other examples might include the pandemic, which certainly the UK has accelerated thinking in relation to fair dealing for educational uses. In Canada, there's an example of overreaching by the reprographic collective Access Copyright, leading to major changes in the way copyright is managed in university libraries. And there are other examples we could discuss. And finally, there's this question of whether or not campaigning for fair use concedes too much. And this is particularly relevant in the United Kingdom. And this concern reflects the idea that many exceptions, even those with a more prescriptive rule-like drafting, have some capacity for broader or narrower interpretations. But if everyone always adopts a narrow interpretation, for instance, because of risk aversion, then those interpretations can become self-reinforcing, including because people will get permissions just to be on the safe side. And those permissions then create a licensing culture, which is used to argue against the operation or the development of an exception. So that's why it's often said that exceptions have a use it or lose it quality. And this is where there's a very important difference between Australia and the UK. In 2014, the UK undertook comprehensive reform to exceptions, including expanding fair dealing to new purposes, introducing new exceptions and reforming existing exceptions. And in the book, I argue that as a matter of legislative drafting, there is a lot of interpretive flexibility in the new fair dealing exceptions and indeed other exceptions, and that signs from the cultural institution sector are that they are keen and well placed to embrace this flexibility. And I'll elaborate on some of this analysis as we move through the presentation. So let's now turn to the Australian proposed reforms. And the one change to fair dealing would be the introduction of a quotation exception. And the first thing to note is that you have to have it, by which I mean a quotation exception is mandatory under Article 10 of the Berne Convention. So those lobbying for reform must impress on the government that a quotation exception is essential to ensure Australia's compliance with its international copyright obligations. But they might also point out the degree to which the proposed content of the Australian provision departs from that of Article 10.1. So on this slide, which I admit is a wall of text, I've sought to compare what Berne says with what Australia proposes to do. Now, one question which we can discuss in the question time if there are nerds who wish to pursue it is whether the mandatory quotation exception in Berne must follow a particular form. But leaving that to one side at the moment, it's just interesting to look at the degree to which Australia intends to depart from Berne, in particular through limiting the proposed exception to particular purposes and to particular uses. Now, with the UK exception, which I have to say looks nothing like what Australia proposes, the UK quotation exception has been well received by cultural institutions who see it as relevant to practices and who praise its drafting as nicely nondescript. But the Australian provision does not share these qualities, and it worries me that the proposal is a weird pastiche of international copyright law, the US Copyright Act, and some autochthonous drafting thrown in for good measure, and that this proposal does not learn the lessons of Section 200AB in relation to the dangers of homegrown provisions. That is, quotation as found in Berne could do significant work. And it's very interesting that despite only having been introduced in 2014, numerous UK participants discussed with confidence using quotation for a range of public-facing activities, despite at that stage there being no case law. They saw quotation as having understandable content. They saw it as relevant to their practices. And furthermore, some academics, and I've cited here Professors Applin and Bentley, and I think Tanya is on the line today. Some academics have gone so far as to suggest that quotation has fair use-like qualities and applies well beyond that sort of paradigm case of verbatim extracts of text being presented in quotation marks. Now, the cultural institution interviewees that I spoke with weren't dealing with the sort of examples that Professors Applin and Bentley were sort of describing as sort of within at the sort of more sort of the boundaries or the sort of their sort of broad definition of quotation. And this perhaps reflects that their uses tend to involve the literal copying of discrete parts. But it's worth noting the amount of blue sky that could be available under a quotation exception. In addition, we also need to bear in mind that the UK didn't just introduce quotation in 2014, it added other fair dealing purposes. And I just want to say something about pastiche, because pastiche doesn't get the attention that it deserves. And in fact, you might even be asking what pastiche is, and how did it get in the UK statute. So there was a strong push ahead of the 2014 reforms for the UK to include a parody exception. And when the government was then drafting that provision, it drew from the Information Society Directive, which used the language of caricature, parody, and pastiche. So pastiche was introduced, but with very little fanfare or attention. All the energy was focused on parody. But one of the arguments I've been trying to develop is that much work can also be done by pastiche. So what is a pastiche? Well, the key thing to note is that it's not, in terms of its ordinary and technical meaning, just another iteration of parody. And I think the IPO guidance reflects the definitions in the OED, in specialist texts, that pastiche has two parts: bringing together existing bits and imitation in the style of. And that suggests on the slide, I think that pastiche has the potential to apply to a broad range of fact patterns. So drawing from some of the cases in the EU and the US, I think that the Pelham and Hutter case actually involves a pastiche. So this case involved music sampling. So a 2-second sample was taken from the Kraftwerk track Metall auf Metall and used in the Sabrina Settler track Ne Mer. The Court of Justice indicated that sampling could, in its view, constitute a quotation. The case went back to Germany, where the relevant German court said that the sample wasn't a quotation, but raised the possibility that it could be a pastiche. And I think that is correct. I think that music sampling is pastiche. You may have also seen over the years some cases coming out of the United States in relation to appropriation art. So this is Carrion Prince in relation to works produced by appropriation art artist Richard Prince. We can query whether these uses are fair, but I think that these works are examples of pastiche. So these are some of the works that were the subject of this case. And more recently, you may have seen the litigation in relation to works by Andy Warhol. Again, we can query whether or not the Warhol uses are fair, but I think they fall within the definition of pastiche. So in sum, in the United Kingdom, expanded fair dealing is not just this sort of undesirable, decidedly second best option. And I use that language actually with reference to the Australian Law Reform Commission report, which recommended fair use and did describe fair dealing as a second best option, I think capturing some of the language of people who had made submissions to that review. And I think that one of the things, a sort of key message from the book, and also from a piece I wrote with Professor Michael Handler, is that in actual fact, we shouldn't suggest that sort of expanded fair dealing is a sort of, significant sort of second best. It's actually got a lot to recommend it. So as I said, that's why I've sort of really come around to be quite a fan of expanded fair dealing as a reform option. So what's Australia done then? Well, it hasn't done fair use, and with these proposed reforms, not going to go with expanded fair dealing. So is it the case that instead Australia is going with the third best option? Now, I just want to emphasize that I actually think that a number of the proposed reforms have a lot to recommend them. So I think there's a lot of good to come in the announcements from the government as to what it proposes to do. But I do have some comments. So what I'm going to do is I'm going to present the comments first, then say a few things briefly about some of the proposed reforms, then sum up, and then we can have our general discussion. But in terms of my general comments about the proposed reforms, although some individual reforms may usefully streamline and simplify detailed rules, the overall package risks creating a complex web of detailed homegrown provisions that are limited to particular users and purposes. And pausing on this point, I think one of the things that we might not like to talk about in Australia is that insofar as fair dealing has worked at all, it's because it was part of an imperial and then Commonwealth network. That meant that, in particular, British decisions gave a lot of content to the Australian provisions. But if you have a lot of homegrown provisions, you increase the risk of no case law, lots of uncertainty, and no use. And this is exactly what happened with Section 200AB. It was perceived as full of legal content, albeit not content that anyone could really put their finger on. Let's compare quotation and pastiche. We have Court of Justice cases, most of which are accessible in English. Now, obviously, this is a double-edged sword, as the Court of Justice has done some pretty crazy things in relation to copyright. So there's always a sort of danger if you're tying your law to developments in another jurisdiction. But when I was researching pastiche, for instance, I was able to draw from the Court of Justice decision in Deckman, which relates to parody. I was able to draw from other Court of Justice judgments, which give sort of guides to interpretive practices. And we now have a number of Court of Justice cases that have considered quotation. In contrast, Australia has not, to my knowledge, had a proper case yet in relation to parody. And what I mean by that is one with an extended analysis of that exception, not just a sort of brief analysis, although I'm happy to be corrected if something's been handed down recently, bearing in mind that parody was introduced in 2006. And certainly I think no case law in relation to Section 200AB. In addition to this concern, there's a second concern, which I've described as winners and non-winners. Now, it may be that the Australian government has another set of reform proposals up its sleeve, but this one really feels like it's directed to educational and cultural institutions, to certain government uses, and a whole bunch of other users and uses are just not within its ambit. So, a couple of specific remarks about the proposed provisions. I'm going to start with what I have termed the good. We have simplification of the request provisions. The Australian statute has a lot of overlapping provisions in relation to researcher use, and I think there is very much something to be said in reducing unnecessary complexity. Now, there's a question about how much certain simplification efforts will lead to change in practices. For instance, there's a suggestion that provisions be extended to private and domestic uses, not just people requiring copies for research or study. I don't know how much that will change existing practices, because my sense was that people requiring copies for their own private use, they just said research and study, and that was sort of accepted. But I think it is good to improve detailed rules by reducing unnecessary complexity. My question is whether the reforms have actually gone far enough in whether there's still too many provisions that are proposed, but we'll see what they come up with. There's also a proposal to have an exception covering online access to collection materials. Again, I think this is the idea of this is sensible, to reflect that institutions have a virtual space and that the sort of browsing and engagement with the collection that occurs in the premises should also be replicated online. The devil will be in the detail, though. So, for instance, the government has indicated that there might need to be limitations on this exception, for instance, allowing contractual override. requiring that institutions determine whether or not that there is an electronic copy available on the market. So the content of those limitations will be significant. I wonder whether there will be a fierce debate in relation to ebooks. Certainly there's been a lot of debates in the UK at the moment in relation to ebooks. But again, this looks like a sensible step. It certainly, to the extent there is a dedicated terminals provision in the UK statute, that was very much well received by cultural institutions here. And indeed, I think those institutions want that provision to be expanded so that it applies to off-site and not just on-site uses. In addition, in terms of good reforms, we have the limited liability scheme for orphaned works. Very happy to see that Australia has not made reliance on this exception subject to any sort of registration procedure. Very happy they've not gone down the path of centralized licensing. So I think this is, I think remedies limitations are the best way to deal with orphaned works for various reasons. Turning now then to things which are less good, and the examples I'm giving are basically in education. And I think the underlying problem is that the government has not just bitten the bullet and said, let's introduce fair dealing for the purpose of education. And they mention that in their analysis, that they're not minded to go down that path. And as soon as you're not minded to go down that path, what that means is tinkering with specific exceptions and more exceptions. And I just wonder whether it would be better just to go with fair dealing for education. So for instance, it would mean you don't actually have to tinker with Section 28. This new exception for freely available materials, well, I have to say, I scratch my head at this, and I'm really keen. Others may have some further explanation of this provision, but it seems to have been motivated by the education license, the statutory license, being applied to these materials that teachers are getting from the internet, and that these are being recorded. Now, if we think that freely available online materials should not be recorded as part of the statutory license, there's a question about whether an exception is the right way to go. But if we are going to have an exception, it just seems to me that reasonable expectation is a very strange choice of words for what is in practice an innocent infringement defense. That is, if a copyright owner has made material available online or has consented to it being made available online, then I don't know whether you even need an exception. Actually, I should just qualify that slightly, not just made available online or consented to it, but so that it may be further disseminated. That looks like there would be a strong argument of an express or an implied license. Now, it may be that the point is that this exception would apply to material that has been made available without consent. But if that's the case, if we want to go beyond that implied license point, then I'm not too sure reasonable expectation is the language one would use. So there's a number of questions about how this provision would work. And as I said, whether this is a desirable development. There's also then been a suggestion that elements of Section 200AB be repealed. I don't think this goes close to far enough to rectifying the drafting issues with Section 200AB. And I just go back to this point. Would it just be better to go with fair dealing for the purpose of education? And in the UK, the evidence is that there's a lot of appetite for digital and online teaching to be caught by fair dealing, not by the other specific educational copying exceptions. This appetite, I think, has only been accelerated with the pandemic. And as indicated on the slides, we have a number of examples of institutions using fair dealing, for instance, in relation to screening entire films to students online. So final couple of slides. What do we do? Well, here's a kind of, this slide brings together the various suggestions I've been making through the course of the presentation. I think if only one thing gets changed in the current proposal, it would be quotation. I think the quotation exception has to be revised for various reasons to bring it much closer to what Burns says. I think the UK drafting for other jurisdictions, I think the Australia should look to that drafting, and it needs to change the quotation proposal. But other things it could do, I really think fair dealing should be extended to education as well. I'd also suggest pastiche, the dark horse of the international copyright system, although I know that not everyone agrees with me in relation to pastiche. But one final set of thoughts, just to remind us, we've been talking about law reform, but it's not all about the law. And one of the things, having worked with the Australian sector over the years, is I think that the sophistication of the copyright practices in Australia have really just increased enormously. Copyright knowledge has gone up. Risk aversion has come down, not in a way that institutions aren't thinking about risk or doing things that are just crazy, but they're taking reasonable risks. And I think all those things also can help change legal interpretations, change the way in which institutions interact with copyright law, and really improve their copyright experiences. So that's it for me. It's now time for questions and discussion. I think the suggestion was that Jill might want to jump in now with some initial thoughts in relation to what I've just been talking about.
Thank you, Emily. Thank you so much. I appreciated the video you made preliminary to this, and also that very comprehensive overview you've just given us. What I'd like to do is just talk a little bit about an overview of what I see as some of the norms and practices changing because of events or imperatives that you've mentioned. And you noticed in the course of your research, and you mentioned this in the video that was available before the session, is that there is more knowledge of copyright around. There is more effective management practices developing, more understanding of licensing. Licenses are becoming more of a negotiation. And there's also, I think, a different understanding of risk management, as you said, and even a different understanding of what copyright is, dare I say. So let me just tell you what I've observed. First of all, the idea of copyright as an economic tool is becoming more prominent. We've had the Productivity Commission report. I have seen quite a few articles where the proprietary nature of copyright is not just coming under challenge, but it's being assumed that it shouldn't be seen as property. In fact, I reviewed an article for a journal recently and pointed out that they didn't even mention Section 196 of the Copyright Act, nor the concept of ownership, and maybe it should have done. But the traditional view is that the purpose of copyright law is to provide an incentive for creation of works, and it must be recognised as property that provides remuneration as a critical component of an ongoing creative effort. But there's increasing recognition, I think. I'm not disagreeing with that, by the way. I'm just saying that there's an increasing recognition that copyright creators are not necessarily copyright owners. There's an increasing recognition that exceptions should be seen as protective of authors and allowing further creation. And Emily, you've referred to some of that just now, and also your article in 2013 in the IPJ covers this issue as well. So copyright is being seen more as a policy tool and a vehicle for advancing societal benefits, not always as property as such. And I've referred already to the Productivity Commission report, which looks at an economic analysis of copyright. The World Intellectual Property Organization has recognized the need to coordinate copyright and competition policies. And there is, as I said, a growing body of commentary putting forward the view that infringement is not necessarily infringement per se. A lot of people would disagree with that, but the question should be, what market harm has been done? Now, this is an observation. I'm not endorsing the views I've just put, really. I'm just saying I've observed them. I think the second thing that is happening is there is a much more robust approach to licensing practices. And I do think that the discussion of reform in Australia and the various reports that have come out have perhaps facilitated this robust discussion. Very much looking forward to the tribunal decision in the case of the universities and the Copyright Tribunal and the Copyright Agency, looking eagerly towards that judgment. In those proceedings, we've seen that the amount of copying and distribution of material has significantly declined in the last 20 years. There's much more, under the statutory license, I mean, there's much more direct licensing with commercial publishers. Universities are adopting management practices that mean there's much more control over what is given to students, not less material, just the way of distributing it through managing teaching resources. The contracts of employment of many academics state that copyright is increasingly belonging to the institution, and institutions are becoming more robust about asserting that ownership. And university policies and guidelines are starting to determine how academics use material and what they upload to learning management systems and so on. So there is a lot more, there's a lot broader choice of material and a lot less reliance on the statutory licensing. At least that's what we've seen argued in the tribunal. Another thing that's becoming, I think, quite aggressively pursued is open source. Increasingly, as I said, it's part of contracts of employment with not just universities, but also in all sorts of institutions. Policies say what you produce, what you do as part of your employment will be open access. The Australian Research Council, the National Health and Medical Research Council, all require as part of funding conditions that most of the research, if not all, is open access. In fact, the NH and MRC have a draft policy which is purporting to take legal precedence over copyright and licensing agreements, whether existing or future. That's draft, it's open for consultation. I'm not saying that will necessarily happen. There a large number of open archive databases. One example is Muse Open, which is providing open access books from university presses and scholarly publishers. Another one is the Open Textbooks Initiative, which is texts from 6 universities that are produced by academics there are available on an open access website. So in other words, there's just a lot less to be paid for in traditional licensing. It's regarded as having been produced by people who are employed to produce that. Increasingly, all organisations, whether universities or libraries, government, museums, archives and so on, are creating material, employees are creating material which is digitised, and the wide dissemination of this material determines the type of content to be used, really. I think another thing to mention is, well, Emily, you've talked about the changes to Australian copyright law, so I'm not going to say much more about that. I'm afraid I'm in furious agreement with you, because I was muted and the camera was off. You couldn't see me nodding and smiling throughout your presentation, but I think the thing about fair use is that it does assume a heavily proprietorial model of copyright ownership, and it leaves the field open for negotiating a very restrictive view of allowable uses. That's one argument anyway. And it can be more uncertain than fair dealing. And fair dealing, in fact, can give more guidance. Now, the second best option of fair dealing, which, I mean, I think questions, and we will cover whether Australia's getting a third best option, but the second best option of that expanded concept of fair dealing with, in the ALRC report, the 11 suggested things that could be included in an expanded fair dealing provision. An interesting thing, well, I found it interesting, is that at the Law Reform Commission, the legal officers, who are among the brightest people that you would find with a law degree, a couple of them said, very experienced people said, don't propose an alternative. Fair use is the preferred model. This is the reform that's being suggested. Footnote, we're already under attack for producing reports that are far too long. So why don't we just cut to the chase and don't propose an alternative model? So this is the desired position, recommend it. However, as Commissioner, I did think that expanded fair dealing was a highly viable option. The best is the enemy of the good. That's been my motto for a long time. And I think that we're much more likely to get fair dealing. In fact, what we have got is reform by 1,000 pen strokes at the moment, I think. Now, Emily, I'll just say one thing. I think fair dealing for education, I think that's highly unlikely in Australia. I think that would be regarded as a sort of basically fair use. And it would just open up so much non-licensing of material that is currently licensed that I think it's highly unlikely. Anyway, I feel that we've talked enough. So, and the audience have been very well behaved. So I think it's Ben, time to direct some questions.
Yes, so we've got a question from Jessica Coates, who I will prompt Jessica to turn her microphone on and ask the question.
Hello, Ben and Emily and Jill. It is great to see you all.
Hi, Jessica.
As someone who was around in your early days, Emily, it's been really great to hear all of your thoughts. And as with Jill, I am in furious agreement with pretty much all of your conclusions. The one place I differ a little bit is I feel like there's another chapter, the Section 200AB story, which is that it's increasing use more recently, but I agree with you, that's been through very strenuous education by organisations like the ADA around exactly that risk management approach you're talking about. And it's still most dominant in like the biggest and most confident organisations like the NLA and the War Memorial. But that is not what I wanted to say. What I actually wanted to say was to ask your opinion. I very much agree with you that the biggest missed opportunity in this bill is the quotation right, and that it could be very powerful, particularly for artists and creative people who currently really are very neglected under the Australian Copyright Act. What I would be interested to know is how you feel. I'm very concerned about it being combined, this piecemeal approach with fair dealing and the impact that might have on the whole concept of fair dealing in Australia. On the one hand, it could be good because by putting in a non-commercial limit in a fair dealing provision, then you're essentially saying all the other fair dealings clearly apply to commercial situations. So you can see that it's not necessarily harmful, but it just sits so much outside the realm of fair dealing, and yet it has the same fairness requirements. I'm a bit concerned with that. Emily and Jill, what are your thoughts on calling it a fair dealing?
Emily, you first.
Sure. Look, I think you don't need to use the fair dealing infrastructure. And actually, one of the things that I had in the slide was that what Byrne talks about is fair practice and proportionality, so that the extent used is proportionate to the purpose. Now, so that's what Byrne talks about. In the UK, quotation has been introduced using fair dealing infrastructure. And I think one would assume that this idea of fair practice gets then sort of subsumed within the fairness factors. It then has proportionality as actually a separate limb in the statutory text. Tanya's actually on the line. I see that she's asked a question. So I don't know if she also would like to jump in with any comments on this point about, do you do it within fair dealing? I mean, I do wonder whether or not, if you want to advance the Applin and Bentley line, is it better to actually just take pretty much the language of Byrne? Because this provides a neater distinction. And one might also think too about, if you are going to use fair dealing infrastructure, do you then include fairness factors? Because one of the things I thought from reading the proposal from the government was they appeared to use the US statutory factors. Now, it may be that that actually does reflect the fairness factors as included, I think, in the research, fair dealing for research defence. But it just seemed, I don't know, it just sort of didn't quite all hang together, that you've got a bit of Byrne and then some fairness factors that don't quite map onto Byrne, and then some other bits which we've added in just to limit what Byrne says. So I think there might be various arguments in favour of just drawing more from what Byrne says. The attraction, though, of keeping the fair dealing infrastructure may be that it just makes things more accessible. Right, again, this point about where do people go to get confidence in their legal interpretations. And I do wonder whether, particularly if the Australian statute was to follow perhaps some of the wording of the UK statute, whether again you can then get this kind of cross-pollination. But Jill, I'll hand over to you, and Tanya, I don't know if you also wanted to say anything in relation to this suggestion.
I'd be interested in what Tanya thinks, actually, since she has written on it.
Tanya, are you able? I'm just trying to imagine whether Tanya is sitting outside with a couple of Labradors.
So if Tanya would like to speak, she's more than welcome. She's written a comment that I can read out for the benefit of everyone. But Tanya's comment was, what is behind the quotation exception proposal? Your analysis that it is flat out contrary to Article 10.1 is correct. It is possibly one of the most problematic implementations that I've seen amongst domestic laws. So I'm not sure if Tanya would like to add anything to that, if she's there. Tanya, if you click on the raise hand button, I will unmute your microphone.
While we wait for Tanya, I'll just say, I think part of the issue is, of course, that the idea of a quotation fair dealing was suggested by the Productivity Commission an ALRC. Like, it's been around for a while, and so they went with that, but then it started getting peeled back, to try to carve out things, but to carve out concerns put forward by rights holders primarily. Yeah.
I think that's right, Jessica. I think the idea originally would have been to follow the Byrne model, but so anyway, Tanya.
Yeah, thank you. Now that I've worked out how to unmute myself, thank you, Emily, for a really fascinating presentation, and also for your comments, Jill. So on this view of sort of how best to implement it, I mean, Lila and I thought about this a lot, and the position we reached is that that we wouldn't want to be prescriptive about how it's implemented in domestic law in terms of the structure of implementation, that there are key features of Article 10.1 that need to be reflected in domestic law, but that this could be achieved in a variety of ways, and that this would pay attention to the fact that you have differences between common law and civil law systems. And we broadly thought that in civil law systems, it would fit better with their scheme to sort of adopt the language of Byrne and then allow judicial interpretation, but that in, say, the US context, actually embedding it within fair use was the way to go. So in the context of Australia, I would say it is this question that Emily has touched upon about whether there is something to be gained by using a pre-existing framework in which there is a kind of confidence and as a result, it will kind of get utilized more. And I think, Emily, your point about being able to draw on the UK position shouldn't sort of be underestimated either. So I would say it's either using the fair dealing kind of framework because of its familiarity and sort of history, or it's using the terminology of Byrne directly. Although I guess I wonder a little bit about how that sits alongside the other ways in which Australian exceptions are drafted. So I suppose I would have my slight preference at the moment would be to probably keep it within fair dealing, but to not have limited it in the way that is presently sort of proposed. I mean, it really is not going to achieve very much, and it's so far away from what Article 10.1 requires. So that would be my initial thoughts. And yeah, and as I said, I mean, we reviewed quotation exceptions in almost all of the Berne Union countries. And whilst there are a number of countries, you know, that are non-compliant because they limit it to certain kinds of works or they restrict it to short quotations, you know, I think the problem with the Australian proposal is it doesn't seem to faithfully implement any aspect of Article 10.1. Okay, thanks. I'll mute myself now.
Thank you, Tanya.
Thanks, Tanya. And I will say as well, you know, we're really looking forward to seeing the draft legislation to see how you know, these proposals actually take form in the legislation as well. We've got a question from Chris Morrison on Jill's response to Emily's point about fair dealing for education. Does Emily think that this could undermine legitimate licensing practices, drawing on experience from the UK and Canada?
Thank you, Chris, for that question. I was actually, I'm glad you raised that, because when Jill was talking about the, I guess, the lack of any likelihood of fair dealing for education in Australia, I did think it might be something worth coming back to. I think a couple of things just to bear in mind in the UK, and so in the UK, there is no statutory license for education. The blanket license in relation to educational copying is voluntary. I think I'm not sure. I wonder whether, just looking at the list, whether James Bennett from CLA is actually on this call as well. I feel like I've got all the right people are on the line, but I think has enormous membership amongst schools and universities with that license, but it's voluntary. And I do think, from looking at the experience of the ALRC, and in particular, my recollection is that the interim report suggested repeal of the statutory licenses, and then the final report did not. I mean, I think there is an issue about how do you do educational exceptions in an environment where you have a statutory license for educational copying. But one of the things I would emphasize in the UK, and also though in Canada, I think the Canadian experience is very important, is I'm not too sure I would concede that even if you had fair dealing for the purpose of education, suddenly the statutory license would become of very little value because of fair dealing. And actually, I think that Canada, I think, bears this out particularly strongly. So in Canada, there was for many years a blanket license that universities entered into with Access Copyright in relation to educational copying. And Access Copyright in about 2010 applied to the Copyright Tribunal for a tariff. And the headline figure on this tariff was an enormous increase in the per student rate that universities would be charged. And the response that emerged over then the years after that application was for universities to pull out of that tariff. And this was really quite a major step, because after there was, for many years, so we have in Canada the Supreme Court saying in a case called CCH and Law Society that research should be given a large and liberal interpretation, that exceptions are users' rights. So really pressing for a quite forward-leaning approach to fair dealing. And institutions basically did very little. There was very little change after CCH. And the Access copyright license gets rolled over and rolled over until we have what can only be described as overreaching by the collective in relation to the headline figure that they put to the Copyright Tribunal. And what happened was institutions, universities just radically shook up their copyright management practices. And what this involved was not fair dealing taking over as the primary mechanism for distributing materials to students, but licensing. And actually, Jill, everything you described about the Australian position of doing it more in-house, more direct licensing with publishers and so forth, that's exactly what's happened in Canada, with then an amount of fair dealing copying taking place as well, but very much the minority. I mean, it's hard to put statistics on it. I spoke with one person who sort of said maybe 15% of the copies of material was copied under fair dealing, the rest of it was under licensing. Now, I think that, and this is, the fair dealing guidelines at York University are going to be considered next month before the Supreme Court of Canada, with some litigation between Access Copyright and York University. But what I think is relevant is that I'm not too sure that embracing fair dealing means saying goodbye to licensing. In fact, I think the Canadian position shows greater sophistication than ever before, because they're licensed, they're properly resourcing copyright and not just cutting a check to some collective, crossing their fingers that the money goes to the right place. And I also do wonder, and maybe it's probably not going to happen, but I do wonder, Jill, whether the initial suggestion of rolling back the statutory license is actually kind of necessary just to allow these sorts of processes and outcomes to unfold. That if you sort of protect the collective through a statutory license, how do you allow for instance, a world where there's more direct licensing with publishers? How do you allow a world for fair dealing? So, but as I said, I'm not too sure you can that Australia will be able to easily roll back from that. But I think I would emphasize that fair dealing for education does not mean fair dealing free for all. No more access copyright, no more CAL, no more CLA. And actually, in many respects, I think it's just one way to also put a bit of pressure back on the collectives to prove why they should exist, right? That they're not, that in actual fact, and I see this to a degree here actually in the UK, that there's no resting on one's laurels in relation to the license being a value proposition. And I think in coming years, there will be more debates in the UK about the value of the CLA license.
So we're almost at time, but Chris has just added a comment here. So he says, it seems problematic if the broader interpretation is effectively off the table in Australia. My experience is that having fair dealing for the purpose of illustration for instruction in the UK has not impinged on primary or secondary collective licenses. Educational institutions would prefer to enter into licenses where these are available on reasonable terms. And
I would echo what Chris said in relation to not underestimating the value of buying some certainty. Now, I think that what I get concerned about with collective licensing is the it's okay so long as somebody is paid fallacy, which I describe as the idea that you're in the school, you're in the library, what have you, you write a check, you send it in, and that's it, your problems are solved because somebody is being paid. And it doesn't matter what happens to that money, but someone has been paid. I think it's really important that there are proper practices to make sure all that money is collected is then distributed to deserving parties, right? So if we're going to be paying money, it should be so that deserving people then get paid. But I do think I do agree with Chris that it is just good to know that there's a whole bunch of things where you don't need to think twice, you don't need to have difficult discussions. You know that you can undertake that copying in this instance here under the CLA license. So I think that we shouldn't underestimate the value of that license in terms of certainty, ease of administration, ensuring that authors and publishers get remunerated. But I think it's figuring out the sort of sweet spot of making sure, though, that those entities are held up to adequate scrutiny in relation to their practices, that there is some sort of market mechanisms that help ensure that pricing isn't ridiculous, that exceptions do play a meaningful role.
I just add that part of the reforms suggested are streamlining the statutory licensing so that, for example, the requirement of a sampling system would be removed. The requirement, it might still be possible, and simplifying methods of determining the fees that are payable. I think this will create more room for negotiation and also remove some of the technological specific aspects of the Act when it talks about surveys and distribution and so on. And then there'll be the capacity to use the digital environment in a way that tracks and rewards use more efficiently. And at the moment, the Act is a little bit rigid with respect, although increasingly, as we've observed tonight, licensing practices have become more of a negotiation and less of a imposition by the statute.
Yeah, Emily, do you have any final comments, or Jill, final comments that you'd like to make? Anyone watching, if there are any more questions or comments that you'd like to raise, please take the opportunity now to do so.
I think just to say thank you, Ben, and Emily, I think was going to say something substantial, but
no, I was going to say something insubstantial.
It's fantastic to be able to do this with Emily, you know, in the UK and the participants all over. So, you know, COVID has accelerated the copyright reforms and also our communications, I guess.
No, I agree with everything that Jill said. I think I might just, I've got the participant list open, and I just wanted to thank I can't thank them personally for anonymity reasons, but a number of people who were interviewees and have supported the project over the years are in attendance tonight. And I think I just wanted to conclude by thanking the Australian sector for the support of this research over the years. Both in terms of some institutions acting as industry partners for earlier projects that I worked on, and then also people giving their time to be interviewees. It was really great how generous people were with their time. So just wanted to thank people who are on the line, who were participants, thank them here for everything that they did to support the project.
And just one final comment from Jane, saying, I think it's very important to share experiences of educational exceptions at the current time, to see which are working well and where there are issues around the world. This is important given the global nature of online education.
And indeed there is, I think that sort of, that is just one thing I would sort of perhaps just draw from, is that one of the issues that we've been talking about in the UK with online teaching is the fact that many students are in other countries which may have very different copyright regimes to the United Kingdom. Now, it may be that the exposure liability of somebody sitting there in Singapore accessing some content is actually quite low. But I think that's just another thing to bear in mind, to go back to that point about homegrown exceptions, and let's make Quotation the Australian version. You know, that it just means that that if you're talking about online activity and cross-border teaching and so on and so forth, it does create challenges. So I think that goes back to that point about with some of the exceptions like Quotation, trying to get it much closer back to the burn text without all these Australian innovations. So there's, you know, it just adds another reason, I guess, for doing that.
Yeah, and I guess to sort of put a wrap up on it, you know, I think what you've both shown tonight is just how important, you know, these reforms are, and these issues have existed, you know, for quite some time, you know, going back before the ALRC review, Jill. I think COVID has just accelerated the need for them, and has demonstrated exactly the sort of issues that have long existed in the Act that we now need to address. And sorry, my dog is destroying something in the background, making her debut appearance in the copyright seminar. And so that is probably a good signal for me to wrap up. I'll remind everyone that our next session is on Wednesday, this Wednesday, 12 to 1 p.m. And that's a regional update talking about the new Singapore copyright bill. So thank you both, Emily and Jill, for joining us, and everyone for joining on the webinar tonight. And really looking forward to seeing you all at other sessions.
Thank you very much.
Thank you, everyone.